All right, so we are convening as mentioned for a hearing on motion in case 2025 M42. The defendant is Ms. Jasenia Amber Raby. Ms. Raby appears today via WebEx. Ms. Raby, ma'am, it's Judge Murphy here. Can you hear me okay?
Yes, Your Honor.
Terrific. All right, and thank you very much for your appearance today. I hope you didn't get as much rain as we got overnight, so you probably were going to be in worse shape trying to navigate the roads today. But
fully completely washed out. So
well, I'm sorry to hear that. Okay, so let me just give you an overview of kind of the way this works, because since you're representing yourself, let's just start with that question. Are you comfortable continuing to represent yourself or for purposes of this hearing as well?
Yes.
I'm sorry, was that a yes?
Yes, sir.
All right, thank you, ma'am. All right, so the procedural history here is that on August 5th, 2025, when you appeared personally, you submitted to the court a lawful challenge to jurisdiction, standing, and authority, as well as an additional, that's a 2-page document, and then an additional 3-page document that was entitled Affidavit of Standing and Rebuttal of Jurisdiction. So generally speaking, the party who makes a motion goes first and argues his or her assertions. You don't have to, if you want to just stand on the pleading, that's what we call it. If you want to just say everything in writing is all I have to say, you can do that. But I want to give you the opportunity first to be able to run through the various points that you have. Then the people, and Mr. Bama is here on behalf of the people of the state of Colorado, the people will offer their position as to your arguments, and then ultimately I'll have to make findings and then either grant or deny your motion. So with that said, did you want to go ahead and begin with anything you want to state?
Everything I have to say is in writing.
Before we even get into the legal weeds of this hearing, let me set the stage for you, because this is one of those cases where everything that shouldn't happen, happens anyway. We've got a self-represented defendant walking into court armed with sovereign-style paperwork, convinced that written words mailed in certified envelopes somehow outrank live testimony, sworn oaths, and decades of settled law. And what makes this even more alarming is what triggered this entire case in the first place. This isn't some harmless paperwork dispute or minor technicality. This stems from a traffic stop involving alleged impaired driving, marijuana use, erratic lane behavior, and children sitting in the back seat while all of this is going on. You're about to watch a judge bend over backwards to explain procedure, rights, and options, only for the defendant to repeatedly decline participation while insisting the court somehow still lacks authority. So keep an eye on how patience, evidence, and reality collide in this courtroom, because by the end of this hearing, the contrast between belief and law becomes impossible to ignore.
Okay. All right, ma'am. Thank you very much. Mr. Bama, sir, do the people have any argument to make with respect to this motion?
Yes, Your Honor, we have argument, and then we do have a witness. Caitlin Bills is on WebEx.
Okay. All right.
Intend to call her briefly.
All right. Very good. Do you want me to swear her in?
Yes,
now?
please.
Okay. Deputy Bills, ma'am, good afternoon. Are you able to unmute yourself and switch on your camera?
Yes, sir. Sorry, I'm trying to get my camera on.
No problem. I know it's a little cumbersome, so thank you very much for your appearance and your getting the WebEx machine thing to work.
Yeah.
Okay to mute yourself?
Yeah, you can mute yourself. If you want to say something, just raise your hand and get my attention, and and you'll have an opportunity, Ms. Raby, to cross-examine Deputy Bills. So what'll happen is I'm assuming Mr. Bama is going to walk through some direct testimony or solicit some of her direct testimony, and then you'll have a chance to cross-examine her. You can ask her questions about what she said during the course of her testimony. You don't have to, but that's your right. All right. Good afternoon, Deputy Bills. Nice to see you. Could you please swear or affirm under penalties of perjury that the information, that any testimony you're going to give today is the truth, the whole truth, and nothing but the truth?
I swear.
Okay, very good. Thank you, ma'am. All right, Mr. Bamus, sir.
Thanks. It's okay if I stay seated?
Yeah,
Okay.
stay seated. There's no
Okay.
formality required.
All right, state your name, please.
Caitlin Bells.
And were you employed as of 4/29/25?
Yes, as a corporal with the San Miguel Sheriff's Office.
And did you receive information about a traffic complaint when you were on shift?
Yes, sir.
And do you recall how you received that information?
Via San Miguel County Dispatch over the radio.
And what information did you receive?
Information about a black Jeep Wrangler or Rubicon Jeep that had a pink crown in the back window with temporary plates that was going a slow amount of speed on Highway 145, 1 mile marker 19, and that was failing to maintain a single lane as the vehicle was driving towards Norwood.
Mr. Adams was concerned. Well, what was he concerned about when he made the call?
The driving behavior of the Jeep and the fact that it was going slow and failing to maintain lane. While also when he had passed that vehicle, he had smelled marijuana and seen the driver smoking what looked like a marijuana cigarette or something along those lines to him.
Mr. Adams had to actually pass this vehicle in San Miguel County to get around safely.
Yes, and he also had to hit his brakes because the vehicle was going so slow, so it impeded his traffic when he was trying to drive and his safety as well.
Okay. Eventually, did you come in contact with the Wrangler?
I did in the town of Norwood on Grand Avenue.
Why did you initiate a traffic stop?
I had seen the Jeep Wranglers stopped at a stop sign on Grand Avenue in North Pine, and it had sat there for an extended period of time. Then quickly turned into the marijuana shop, Alpine Wellness in Norwood. Within less than a minute, it had pulled in there. He had given good descriptors of exactly what he had seen and observed and smelled. I initiated the traffic stop and contacted the driver, Justina Rager.
And what was your tone when you first initiated the stop?
Conversational. Well, when I first started it, I had yelled stop at her because she almost backed up into my car. But after that, it was conversational.
This moment right here is crucial, and a lot of people miss why. The judge isn't being casual or friendly just for fun, this is him creating a clean record. He's confirming that the defendant is choosing to represent herself, understands the process, and is being given every reasonable opportunity to participate. That matters because self-representation doesn't give you special powers, it actually removes safety nets. When defendants file jurisdictional challenges and then refuse to argue them verbally, courts don't panic. Written filings don't magically suspend proceedings. The judge explains exactly how motions work, who argues first, and what happens next. This is procedural fairness in real time. The irony here is that sovereign-style filings often claim courts ignore due process, yet what you're watching is the court practically narrating due process step by step. This is the moment where participation could matter, but choosing silence is still a choice, and choices carry consequences.
And was there anybody else in the car with the defendant at the time of the stop?
Yes. Her mother-in-law was the passenger, and then she had 3 young children in the back seat.
And eventually, you do have a conversation with the defendant, and I'll say that that's beyond the scope of what we're talking about today, but just to kind of paint the complete picture, you have a conversation with the defendant, and then is she ultimately charged with driving under the influence of drugs?
Yes, sir.
Okay. And did she consent to any tests?
Yes, she consented to voluntary roadside maneuvers.
And how about any chemical testing?
Yes, she consented to a chemical test of her blood. And when she consented, she said that there would be THC in her blood.
Okay, and what else did she tell you anything else when you were conducting your investigation?
She had told me that she had smoked marijuana. It had been outside of her car. And this was after she initially had lied to me about that she hadn't smoked at all, and she changed her story. But she had pulled over and she had smoked outside the car, and it had only been one joint, even though the car smelled like burnt marijuana on the inside, and there was burnt marijuana cigarettes that were visible in the ashtray.
Okay. For the purposes of this hearing, those are all the questions that I have.
So Ms. Raby, this is now your opportunity to cross-examine Deputy Bills about anything that she offered as testimony. If you'd like to do that, you're welcome to go ahead. You don't have to do it, but it's your right.
I don't have any questions to cross-examine at this time.
This is a classic move, and it almost never works the way defendants think it will. Saying, "Everything I have to say is in writing," doesn't freeze the courtroom or force the judge to abandon testimony. Courts don't operate like email inboxes where whoever sends the last message wins. Motions are evaluated against evidence, testimony, and legal standards, not vibes, not stationery, not how official the paper looks. By declining to argue verbally, the defendant is effectively handing the narrative to the prosecution. The judge even warned her that she didn't have to speak, but that silence isn't leverage, it's surrender. And here's the part people don't like to hear: judges have seen these arguments hundreds of times. Jurisdiction challenges without substance don't shock the system, they get methodically dismantled. What's coming next is evidence, sworn testimony, and facts, and paperwork alone can't cross-examine a witness.
You are hereby excused, Ms. Bills. Thank you very much for your time and appearance today. I appreciate your working with the WebEx machine as well. Okay.
Yeah, sorry about that. Have a good day.
No worries. Okay. Do the people have further argument or evidence or presentation?
No further evidence, ready to make argument. I don't know if I think just for protocol,
Ms.
I'm
Raby.
gonna open up to Ms. Raby first.
Yeah. So did you want to, Ms. Raby, this is the time when you can make effectively what would be a closing argument, a summary of what your assertions are in support of your motion. Again, you don't have to say a word, but if you wanted to offer a global overview of what you're advancing in your motion, you're welcome to do that. Do you wish to do anything like that?
No, everything that I have to say is going to be written to you in certified mail.
Mr. Bamasir, do the people wish to make?
Yeah, thanks. In order to make a traffic stop, the police must have reasonable suspicion that a person has committed a traffic violation or other offense. Suspicion is reasonable when there is an articulable and specific basis in fact to support it. And the police must have specific and articulable facts or rational inferences from those facts, which would support a reasonable suspicion of criminal activity and thereby justify the intrusion into the defendant's personal activity. The reasonable suspicion here was articulated by Deputy Bills, and it started with a citizen informant or ready report, if you will. And the ready report is something that has been dealt with in Colorado courts before, and they can serve to justify or create that reasonable suspicion. And I think in this specific case, that reliability is all the more established based on the fact that this was a trained law enforcement officer, albeit he was working for the jail at that time and not necessarily a patrol officer, but still law enforcement and still understands what's required when you're calling in a ready report. Also, peeling in front of the marijuana store and almost backing into Deputy Bills during the stop, again, that just leads to the reasonable suspicion for this stop. And the site that I'll have there is kind of the cumulative reasonable suspicion is People v. Garcia, 789 P2D 190192. Colorado 1990.
This testimony is doing exactly what it needs to do legally. Reasonable suspicion doesn't require certainty, it requires specific, articulable facts. And Deputy Bills is laying them out clearly: erratic lane behavior, unusually slow driving, traffic obstruction, a citizen report, the odor of marijuana, and visual confirmation of smoking while driving. That's not one vague hunch, that's a layered chain of observations. Add in the location, timing, and the defendant's behavior at the stop sign, and you have more than enough justification for a traffic stop. This is why courts consistently uphold stops like this. It's not about opinions or personal feelings, it's about whether another reasonable officer would have acted the same way. And the answer here is yes. Every box for reasonable suspicion is being checked in real time.
All right, Ms. Raby. I just want to make sure that I, as fully as I can, address some of the points that you articulate in your written motion. And then I'll also I'll layer in the discussion that the people have highlighted here about the reasonable suspicion or lack thereof, et cetera. But I think I did, as part of the record during your last appearance, inform you that in any criminal case, including this one, that the court has authority over that case as a result of Article 6 of the Colorado Constitution, Sections 1 and 16, as well as a basis being Colorado Revised Statutes, Section 13-6-106. Further, that Article 6 of the Constitution, the Colorado Constitution, more specifically Section 17, does grant the court subject matter jurisdiction, meaning that this type of act, this type of case is appropriate to be heard in the county court. In addition, that point is emphasized further by Colorado Revised Statutes 18-1-201 and Colorado Revised Statutes 13-6-106.
This is where the tone of the case quietly shifts, even if no one says it out loud. Impaired driving allegations are serious on their own, but when children are in the vehicle, courts pay closer attention. That's not moral judgment, that's risk assessment. The presence of minors raises safety concerns, potential enhancement issues, and broader implications about decision-making. And notice how calmly the deputy delivers this information. There's no exaggeration, no dramatics, just facts. That calm delivery actually strengthens the testimony. Courts trust consistency. When combined with the admission of marijuana use, the changing story, and physical evidence inside the car, the credibility gap widens fast. At this point, the case isn't about jurisdiction theories anymore, it's about accountability and public safety.
Noted for the record during your prior appearance, and we'll do so again today, that personal jurisdiction was in effect achieved or perfected as a result, first, of the issuance of the underlying summons and complaint, which was served to you by, I guess, Deputy Bills, yes, back on April 29th, 2025, during that traffic stop that was just discussed as part of her testimony. And then your personal appearance here on August 5th, 2025, also reaffirmed that personal jurisdiction, meaning I have authority over you as a person. I have authority over this case given the subject matter of the case. And with that, I also want to draw your attention to my oath of office then, that was administered on the 8th of June, 2020 by District Court Judge D. Corey Jackson, as well as the State of Colorado Department of State having issued a certificate certifying, more specifically the Secretary of State certified that on November 8th, 2022, that I, Sean Murphy, was duly retained as a county judge in the 2022 general election, that being the county judge for San Miguel County, Colorado. So let me turn then, with that background highlighted, to some of the assertions you make. Your document that's titled Lawful Challenge to Jurisdiction, Standing, and Authority, in which you say this is a lawful and peaceful